Hello, everyone. Welcome to Last Prisoner Project and Kush.com monthly webinar. This is our fourth webinar in the series, and I am so excited to have an amazing group of panelists today. If you are new to this monthly webinar, it's really amazing for us at Last Prisoner Project. We really get to dive deep into our organization, the work we're doing. And so within this series, we have really tried to give kind of an overview about us, our organization, our staff, our constituents. And then each month we've kind of done a deep dive into a different facet of the work that we do. And so we had some of our constituents on to talk about the reentry process and that piece of our direct service work. Last month, we had our policy team on talking about the work that they have been doing. Can everyone hear me okay? My panelists, I got to note that I was a little, okay, great. I'm just going to move very close to the screen and speak up so everyone can hear me. So last month we had our policy team on, and that work is really crucial to creating long-term systemic reform. At Last Prisoner Project, our goal is really to make it so that one day we no longer have to exist, right? We have gotten to the point where every last cannabis prisoner is free. And that work that our policy team is doing is really crucial to that systemic reform. But of course, in the interim, a core focus for Last Prisoner Project is our direct service work and our direct legal services. So I'm incredibly excited today to have three of the pro bono attorneys that work with us, each in different areas of our legal services, to talk about our Clemency program, our compassionate release program, and some impact litigation that LPP has gotten involved with recently. So I'm going to start by first having each of our panelists introduce themselves, and then we'll be doing a deeper dive into each of that work. So Kiara, if you could just introduce yourself and maybe just give a brief overview of how you got involved with cannabis law and this work.
Well, hi, everybody. My name is Kiara Juster. And what brought me to this work and ultimately Last Prisoner Project was the experience I had straight out of law school as an assistant state attorney, where I thought I could exercise prosecutorial discretion only to find that it was a myth and that the war on drugs was alive and real. So I committed myself to furthering justice in whatever way I could, including through cannabis policy and reform, which led me to Last Prisoner Project. And when Sarah first reached out to me about the work that was going on at Last Prisoner Project and some of the constituents who were currently incarcerated, I was shocked to find out that people were still spending their lives behind bars.
Thank you, Kiara. Next, Jen, if you could do a brief intro and same how you got involved with cannabis law and this work specifically.
Sure. Thanks, Sarah. Hi, everybody. I'm Jen Fisher. I'm a partner in the San Francisco office of a law firm called Goodwin Proctor. And Goodwin is an international law firm. And we were really one of the first major law firms to establish a cannabis industry practice group. So in my practice, I represent cannabis companies at all levels of the supply chain, as well as investors, including private equity firms and venture capital firms investing in the space. And the focus of my work is on regulatory compliance, litigation, and government investigations. So I represent cannabis companies and their investors on any issues related to regulatory compliance, or if they're hit with a lawsuit, or if they come under investigation from the government. And so I wanted to couple that practice, which obviously involves representing a lot of companies and individuals who are profiting from legalization and the expansion of the legal cannabis market with my pro bono practice. And that's what led me to the Last Prisoner Project. I felt really strongly that if I was going to be working with people who were doing really well in the industry, that it was really important for me as a lawyer and for Goodwin as a law firm to make sure that we were providing services to people who might otherwise not have access to a lawyer, including those who are incarcerated. So I'm thrilled to be partnering with the Last Prisoner Project, feel so strongly about the work that they're doing, and I'm very happy to be here today.
Thank you so much, Jen. And finally, Fatima, if you could introduce yourself.
Hi, I just want to thank you for having me today. My name is Fatima Afia. I'm an attorney at Hiller PC. We are a law firm located in Midtown Manhattan. I actually, like most attorneys, went to law school wanting to use the law as an instrument for social change. And luckily enough, I was introduced to the current managing partner of Hiller PC, Michael Hiller, when I was in college at John Jay College of Criminal Justice, where he was teaching constitutional law. And it was there that I realized that I actually could, find a way to make some really important impact on society, really help people in a way that, might be harder to do in other industries. There's so many tools that lawyers have in their toolbox. And I really learned a great deal in that class. And actually from there, I became a paralegal for Michael Hiller's firm at the time, which was Weiss and Hiller. And then I sort of just stuck through it. About 3 years, I was a paralegal with them. I went to law school, came back as a summer associate at Hiller PC, where Michael Hiller was then the managing partner. And I then came back after graduation, and I've been there for about 4 years now. During my second year practicing with Hiller PC, they had already created a really substantial cannabis law practice. But I had primarily at that point been doing most of the litigation work at the firm for my first 2 years. And then we decided to bring a lawsuit against the DOJ and the DEA in 2017. And it was in order to get cannabis descheduled from the Controlled Substances Act under certain constitutional rights that we have. So as part of my work on that lawsuit, as a second year associate, I really was given an incredible opportunity because it was actually my task to do the bulk of the research on the history of cannabis use in the world, 10,000 years worth of history, and also the prohibition of cannabis all throughout the world, and particularly in the United States, and the racially motivated factors behind prohibition. And it was at that point, doing that research, contributing substantially to the complaint in that lawsuit, that I really realized how passionate I was about being involved in this space, particularly from a social justice perspective. So ever since 2017, I've been working on this lawsuit, and as I'll be discussing later, we're actually headed for the U.S. Supreme Court now. But by getting involved in that litigation, I then also started to branch out into more transactional areas in the space as well. And so it's a really amazing industry. It's constantly evolving. It's incredibly challenging, but also really excited to be involved in. And of course, it's always most exciting to be a part of something where you're actually helping people's lives, changing their lives. So, and, through this litigation against the DOJ and DEA, we were introduced to Sarah from Last Prisoner Project, and we are so happy to have their support in this litigation. And just thank you again for having me.
Hiller, who have firm-wide gotten really involved in some of the pro bono efforts with Last Prisoner Project, and David Feldman at Hiller for representing us in our pro bono needs, which we are super grateful for. All right, well, so we're going to dive again into each of the facets of the work that you guys briefly touched on. And I just want to let everyone know we will have about 15 minutes at the end for Q&A. I already see questions coming in, which is amazing. So just put those in the chat, or if you're on YouTube, post it, and we will have some time at the end to hopefully get to those questions. So I'm going to start with Kiara. Kiara is helping us on a clemency case. And when Last Prisoner Project started, our legal services really were pretty narrowly focused on our clemency efforts. And typically the way that Last Prisoner Project structures our clemency program is that we work both federally with the White House as well as state by state to work with the executives that hold the clemency power. And generally when we talk about clemency, it is the executive authority to provide retroactive relief. And that comes in sort of two forms. The first being a pardon, which is maybe most similar to people that might know about expungement or record clearing. It kind of wipes the slate clean for someone. But the aspect of clemency that we are most focused on at LPP is commutations. And that is to actually resentence someone and release them from incarceration. And so again, typically how we do that work is by working with an executive officer in a state, crafting a category of clemency for those still incarcerated in that state for cannabis charges. But something else that Last Prisoner Project has started to do is when we find a really egregious case of someone still incarcerated on cannabis charges, we might focus on that one individual, even if it's in a state where we aren't working with the executive office. And that is exactly the case with Richard DeLisi. So Kiara, I will let you kind of dive into Richard's clemency case and just the background on Richard.
Well, thank you, Sarah. And when I first heard about Richard, I truly was appalled. Richard DeLisi is the longest serving nonviolent cannabis prisoner of the drug war who currently remains behind bars. He has been behind bars since 1988. And I think that we all have a commitment to work with those traditional operators who languish behind bars while in states, particularly the states where they're languishing, for regulated markets. So Richard DeLisi was sentenced to 90 years on 3 counts, 90 years, 3 30-year terms to be served consecutively for cannabis trafficking, conspiracy to traffic, and a RICO violation. This was in fact his second encounter with the system, the first also being nonviolent cannabis crime. And we're talking about the 80s here. But Richard, he was born February 1949 in a really tight-knit community of Breezy Point, New York. And I mention that because the community he grew up in truly reflected the values that he embodied later in life. Caring, loving, loyal, a family man. In fact, every generation for the last 100 years has adopted in his family. Richard himself at one point adopted a 9-year-old boy. His uncle went on to adopt a 13-year-old. So this is truly a loving family. But when Richard was growing up, he never learned to read or write. He was dyslexic, but back then they didn't have a word for it. And in the strict parochial system, he was not given the attention he was needed. In fact, at one point they said he wouldn't learn at all. There was something wrong with him. And they sent him to an institution where at the age of 9 or 10, my own child's age, he witnessed horrors right out of One Flew Over the Cuckoo's Nest. And that really affected him. He really didn't think that he had any opportunities in life. Eventually, he became a mechanic, but he saw the opportunity in Florida at the time to be involved in cannabis trafficking. He never was involved with any other substances because he was very, very nonviolent. This is a man who has embodied peacefulness from the time he was a young child. And he saw the violence that accompanied the other illicit trades, and he wanted nothing to do with it. When he had his first encounter with the system, he was sentenced to 1 year, but because it was the first RICO case, racketeering influence corruption organization case in Florida, they seized all of his assets, he and his brother as well. And his brother served more time in that case. He was found to be more culpable. It matters that these assets were seized because when Richard came out, there was a real lack of opportunity. At this point, he still couldn't read or write. He wasn't sure how to support his family. And family for Richard goes beyond just blood. It extends to those he grew up with. This man is more popular than, I dare say, the entire legal team combined. He has more friends reaching out to support him than I've ever seen in my life. But he needed to support his family, and it leads to the case that he is now incarcerated for, and that was a case of entrapment. He never actually trafficked the cannabis in. The cannabis in this case belonged to law enforcement. He was set up by an individual who was on the payroll for the Florida Department of Law Enforcement, along with his wife, had set up 75 different individuals. In this case, there was a lot of negative feeling about the fact that this was a cannabis trafficking case in a more rural area of Florida that was more conservative even at that time. 15 years later, at the state attorney's office in Miami-Dade County, I assure you, I didn't see anything like this, which is why I truly was horrified when I heard that in Florida, people have been given 90 years for cannabis, 90 years for non-violent offenders. And even at the time, this really was an outlier. The sentencing guidelines recommended between 12 to 17 years. The prosecutors felt strongly that the brothers in this case, Richard and Ted, be treated differently. And they were both given 90 years. But Ted, he successfully appealed one of those convictions on the conspiracy. And Ted was released 7 years ago. Ted is turning 79 tomorrow, and every day he wishes he could spend time with his brother. This sentence was unjust from the very beginning, and Richard could have spent every single day since 1988 bitter behind bars, but he hasn't, because that's not the kind of guy he is. Richard spends every day trying to better himself and those around him. The time that he has spent inside turned out to be time well spent, in that he was able to have a positive impact on his community, both within and outside of the prison. Richard was able to learn to read and write while behind bars. He had a friend who expressed to me that one of that friend's first memories was at school when Richard was around 6 years old, listening to Richard screaming in the halls because he was being reprimanded for basically not being able to read. So that really compelled this person to become a reading specialist. And they sent Richard phonics books. And over the phone, Richard learned to read and he learned to write. And he knew that that system to teach people phonetically was not being used in the prisons. So Richard set up a class. They gave him a classroom and his choice of aid, and he was able to teach people how to read. And he told me that the best feeling was when those gentlemen would come up to him and say that they had written their first letters home to their mothers. I can't even imagine waiting until your child is an adult to see "I love you, mommy" on paper. But it wasn't just those individuals who took the class that Richard tried to help. If Richard saw boys who he deemed troubled, he called them boys because right now he's a 71-year-old man. They definitely have been boys over the last 32 years. He wanted to help them in whatever way he could. He'd give them snacks and teach them to read, and also counsel them and mentor them so that they wouldn't end up spending the rest of their lives behind bars, as it looked like he would. I have to go back to the fact that this sentence was an extreme outlier. I have a little chart here, and I'll hold it up. This shows RICO offenses in Polk County, and that little dot up there, way up there, is Richard. That's practically 11 times the longest sentence that anybody received on a RICO violation in Florida, in Polk County. So that really is shocking. But it wasn't just learning to read and write that has led Richard to giving back to his community and himself. He's taken a number of courses, over 30 courses, and that was over 11 years ago that we were at that number. And he's very, very devoted to his faith. He's part of the faith-based community there. And I had the honor of speaking to the chaplain, who has known Richard in that capacity and did not know what Richard was in for. And I tell you, there was a silence when I told him that Richard was the longest serving non-violent cannabis offender currently incarcerated in the United States, because Richard has never once brought that up. This is a very humble man who just wants to serve. And the words that this chaplain used to describe Richard are the same words that I've heard time and time again from those who have known him and loved him his whole life, that he's a caring person, a responsible person, a person who wants to provide for others, and a person who's affable and people enjoy being in his presence. Richard made the most of every day, but unfortunately his absence was felt very strongly by those on the outside, mainly his children. Richard had 3 children when he went into prison. Richard only has 2 children now. One of his sons passed away because of addiction. He didn't have his father in his life. Addiction to substances that are legal in all states every day and prescribed by doctors countless times over. Yet Richard lost his son. Richard also has a daughter who every day for the last 32 years has missed holding her father's hand, who held out hope at one point that her father would be released like her uncle, and bought her daddy a puppy and a new car, and was hoping her dad would come to be reunited with her. But sadly, he wasn't. And she suffered a horrific accident where she was gravely injured while undergoing brain surgery. She suffered a stroke. Miraculously, she survived. However, she remains paralyzed, partially paralyzed, and is in a facility to teach her all of the steps again that would be much easier if she had her dad to kiss her forehead. She would love to spend time with her father and her son. Richard has another son who in fact lives internationally in a country where people are treated very differently than they are here when they are incarcerated, and cannabis is treated very differently than it is here. And he's witnessed a system evolve while his dad has remained incarcerated. And he has done whatever he could to help his father. Yet what can you do? But despite all of these losses, Richard has persevered and helped his family from the inside. Because of his longstanding commitment to his faith, he was able to facilitate services for his son while he was incarcerated. He was able to find the facility for his son's services to be held. Richard has had support from corrections officers dating back to when he first applied for clemency in the early 90s. I've read letters 27 years old about how this is not your ordinary inmate. The legal team has spoken to the assistant warden, as well as a prison expert who served in prisons for 30 years. And Richard is not a threat to society. People are surprised when they hear how long he's been inside, and surprised to hear that he has a very small disciplinary record that includes things in the 90s, such as a visitation violation, which was a smooch, as he puts it. And in fact, it's been remarked about how impressive his lack of record is, and all of these certificates he's gained, and the positive impact he's had while he's been incarcerated. Richard is fortunate that he has a whole community of people who want to support him on the outside. He has had over a dozen offers of places to live, including places, his sister, who is not too far from the facility and has separate accommodations for him so that he could safely quarantine were he to be released, because Richard, like many men his age, suffers from a number of serious conditions, health conditions that put him at a higher risk were he to contract COVID-19. So clemency really is Richard's only hope. And along with a wonderful legal fellow from LPP, Mariah Daly, and another very hardworking young attorney, Elizabeth Buchanan, and Michael Bernardi, we've been pursuing how can we get Richard out. So the clemency process in Florida is different than it is in every state. That's how it works, and different, of course, than it is federally. And in the state of Florida, the power is vested in the governor through the Constitution, Article 6, Section 8A. And it is the governor and members of the cabinet collectively that comprise the Clemency Board in Florida. And it states that clemency is an act of mercy that absolves the individual upon whom it is bestowed for all or any part of the punishment that the law imposes. This is a lengthy process. And before Last Prisoner Project was involved, Richard, on his own, had tried to initiate this process, which was a surprise to his family as well as his legal team. And what we have done is everything we can to compile a packet to supplement this petition. And last week we submitted this 231-page document full of expert opinions, as well as countless letters from those who know Richard best. We are praying that an act of mercy happens and that Richard is granted clemency, because if this process continues indefinitely, Richard very well could die. Somebody is considered elderly at age 55. Richard is 72. He has been incarcerated since 1988. And while he says that the facility was doing an excellent job managing his chronic conditions prior to COVID, by excellent, he meant quarterly visits, he is now watching his friends pass away. So Richard's, where we are in this process is that we are hoping that the investigation goes expeditiously so that a recommendation can be made to the board. We are hoping that the board convenes via Zoom because we understand the very real health threats associated with meeting in person in Florida. In fact, one of the reasons that we hope the governor uses his power under Rule 17 and Rule 17 of the Rules of Executive Clemency state that in cases of exceptional merit, any member of the Clemency Board may place a case on the upcoming agenda for consideration. And we are asking that Governor DeSantis exercise his executive clemency and bring this case before the board expeditiously under Rule 17 before it is too late for Richard DeLisi. Because in his facility, there have been a number of deaths. There have been 4 deaths so far of prisoners detained in South Bay Prison. There have been a number of guards, I believe the number is 82, who have tested positive for COVID-19 in South Bay Prison. And the number of inmates who have tested positive for COVID-19 in South Bay Prison is close to 500. This is a prison that is very full of people in a community that is being hit incredibly hard by COVID-19. And if Richard were to contract it, as I said before, he has the pre-qualifying conditions that put him at higher risk. We are hoping that everybody directs their attention to Last Prisoner Project and also visits freedelisi.com, emails Governor DeSantis, and ask him to free Richard DeLisi. Oh, here we go. Also, as of yesterday, there have been 86 deaths of those who are incarcerated in Florida. And this is a huge number. We need to get this number down. We need to release nonviolent cannabis offenders, particularly who those are elderly. And, if we have to talk about it, let's just look at the numbers, that economics that are involved here. Already, over $1.3 million has been spent incarcerating Richard DeLisi. Over $70,000 a year are spent by Florida taxpayers to keep elderly people behind bars. And Richard, he's had a number of surgeries. He uses a walker. He has degenerative disc disease. He takes, I believe, 10 medications. He's costing a lot more than $70,000 a year, money that Florida could use to invest in its medical infrastructure and education. Also, while I may not be an expert at math, I know that 32 plus 2 doesn't equal 90. And Richard is set to be released in 2 years. Every time I check the Department of Corrections website, the date is sooner and sooner. Right now, it is in July 2022 that he is set to be released. So I ask, what good does it do that when we continue to detain these incarcerated cannabis offenders, traditional market operators who remain incarcerated? And I applaud the efforts of Last Prisoner Project, who and Steve D'Angelo, who shows that when you are successful in this industry, you aren't truly successful if you aren't giving back and making sure that the last cannabis prisoner is freed. And I was hoping that this could all be accomplished by tomorrow. So on Ted DeLisi's 79th birthday, he was able to sit on the bay of the lake where he lives with his brother. But I'm hoping maybe for his 80th. So thank you, Sarah.
Well, thank you so much, Kiara. Thank you for the hard work the entire legal team has been doing on Richard's case. I want to move on, but I think I might have some questions to circle back to. But one thing that I think you really articulated, and that was a very detailed, not just overview of the case, but the clemency process. And as you noted, the clemency process is different state to state. But I think coming off of filing that 231-page supplement, what you're showing is that the clemency process at its core is really not relitigating the case, but it's showing why someone deserves release. And I've always said that we are at Last Prisoner Project are incredibly lucky because the clients that we work with have those incredibly compelling stories. They are incredibly good, kind, empathetic people with lots of support. So they really are the perfect candidates for release. And Richard certainly exemplifies that. And I know that is something that Jen has found with her clients. And so the piece of our legal process that Jen has been working on, as Kiara noted, COVID presents an urgent health risk for anyone that is incarcerated currently. And so when COVID really started ramping up in the US and infecting our prisons, LPP launched a compassionate release program. And Jen has been really instrumental in getting that program set up, as has Goodwin been. And so Jen, I would love for you to kind of explain the compassionate release process, why COVID presents this opportunity. And then of course, if you wanted to share some of the cases you've been working on.
Sure. Thanks, Sarah. Yes, we're really excited about Goodwin's partnership with the Last Prisoner Project and our efforts to seek compassionate release for LPP's constituents. So for those of you who may not be familiar with what compassionate release is, in 1984, the Sentencing Reform Act was passed, and that was the first time this concept of compassionate release was introduced into the criminal justice system. And it was really geared at prisoners who are suffering from debilitating medical conditions or aging in the prison population and finding an avenue to grant them release. And that's why it's called compassionate release. So the statute lays out a number of factors. Most of them have to do with health conditions, changes in someone's family life if they're the sole caregiver, and they can make a showing that they need to be released in order to care for a loved one, or if they're aging in prison and that is, and they have debilitating medical conditions and the prison is unable to provide them with the right care. These are all factors that could lead to compassionate release. The big problem with this idea, while well-intentioned, was the execution of it. Really, Congress left it up to the Bureau of Prisons, which is the federal agency that runs all of the federal prisons, to evaluate prisoners' requests for compassionate release. And all too often, those petitions and requests were just ignored or flat out denied, even if there was good cause. And so this compassionate release program was set up, but really wasn't being implemented. Prisoners couldn't take advantage of the opportunity to seek release because it was really up to the warden in their facility. And they had no avenue outside of BOP's administrative bureaucracy to really advocate for themselves. And so in 2018, when Congress passed the First Step Act, which is really a comprehensive criminal justice reform law, Congress took a close look at this, and really we've studied the legislative history, and really Congress was focused on providing more avenues to take advantage for prisoners to seek compassionate release, and also to kind of take it out of just being a strictly BOP process. So what the First Step Act did was allow prisoners who had made a request for release to the warden that had either been ignored or denied, that they could go back to their sentencing court and seek relief directly. So they were able to appeal basically these decisions of the BOP on their own without relying on the BOP to do it. So that was really a pretty significant change. The problem is that a lot of incarcerated individuals don't have access to lawyers to be able to pursue this avenue of relief. So while they may be able to fill out the form and go through the process in the prison of trying to request relief, after that, they really need skilled lawyers who can go back to these federal courts and put together really compelling motions for compassionate release. And so that's what we're doing at Goodwin. We're working with the Last Prisoner Project, who's done a phenomenal job of sending very, very deserving, compelling constituents to us. And we've developed teams of attorneys throughout our law firm across the country, led by partners who are sophisticated criminal and civil litigators, and a great team of associates supporting them to put together motions for compassionate release. And so it's a fascinating process, and we really get to know our clients, because the approach we've taken to these motions is to make them as holistic as possible, echoing a lot of what Kiara said about putting together a clemency application. We're kind of doing the same thing at the compassionate release stage. And what allows us to do that is that sentencing court judges, and oftentimes they're the same judges that sentenced our clients, so they looked at it once and handed down some very tough and disproportionately long sentences. So we're asking them to revisit those decisions, which is, for anyone who practices in federal court, that's not an easy path. And so what we really try and do is focus both on the grounds for compassionate release, which under the law are called extraordinary and compelling circumstances. And that's where we're able to link the outbreak of COVID-19 in the prisons to our applications. And we also look at the sentencing factors, the 3553 sentencing factors that are at play anytime a federal prisoner is sentenced. And a lot of that focuses on the nature of the offense. And so that gives us the opportunity to talk about cannabis reform, the spread of legalization. A lot of our clients were sentenced at a time prior to legalization. And so the very activity for which they were convicted is now legal in the states where they were sentenced or in surrounding states. And so we're able to capitalize on the change in attitude and the change in law in many of these states that have legalized. But we also really take a very personal approach to these compassionate release motions. And I'll use one example of a client we just have been working really closely with, named Philong Chuang. And Mr. Chuang was a refugee from Vietnam during the war. He built an entire life for himself in the United States out of nothing. He started a business, he started a family, and he started using cannabis to relieve some pain that he was feeling. And he got caught up in a larger criminal operation, and the whole conspiracy was charged, and he was the only one to get a long prison sentence. And he got 87 months in prison for a nonviolent cannabis offense. It was his first ever offense, his first infraction. He had never been in trouble with the law before. And so what we did was we decided to tell a story. We did a lot of legal advocacy. We walked through all of the factors that a federal district court judge needs to look at. And we provided a lot of evidence about what's actually happening in the prisons with COVID-19, which is not necessarily how the BOP is representing it. So we're looking at the outbreaks, we're looking at testing, we're looking at the reporting of cases, and then we're looking at the surrounding areas. Because as we learned from our client, people were coming in and out of his facility, not wearing masks, not being tested. And they're out in a community, and his prison is Atwater in California, which is now a COVID hotspot. So we were able to link a lot of COVID statistics to his medical condition and his age. He had a lot of, he's struggled with a lot of health issues while in prison that put him at risk of COVID, and his age and the stats around COVID-19, and really paint a bleak picture, establishing really what we believed were extraordinary and compelling circumstances warranting compassionate release. But we just didn't stop there, because for a lot of federal court judges, that's not enough. They're seeing tons of these compassionate release motions coming in from prisoners all over the country. They're getting a little bit fatigued. We're seeing more and more denials. The DOJ is taking the position throughout U.S. attorneys' offices all over the country that unless someone's in the very, very highest risk category as determined by the CDC, that just as a policy, they're going to oppose compassionate release petitions. And so we really wanted to do more than just make that argument. So we collected tons of letters of support and created a reentry plan for him with his family, demonstrating to the judge that he had a safe place to live, access to the medical care he needs, employment opportunities, and a loving and caring family waiting for him when he got released, which is actually very important. I think a lot of judges want to see that when someone's released, they're going to be successful when they're back in the community. So all of those factors, I think, were really persuasive. And so I'm very thrilled to share the news that just this Monday, the court granted our motion. Our client has now been removed to a special quarantine facility of the prison for 14 days so he can quarantine in the event that he had been exposed to COVID while incarcerated. He won't be spreading the virus when he gets released. We were able to share this very, very good news with his family right after we got the order from the court. They're thrilled and relieved. They've been incredibly worried about that, about him. They're scheduled to pick him up. They have a time and a date where they're going to meet him at the doors of the prison and take him home. So we are so thrilled that our first motion that we filed was so successful. We have 7 more in the works, and we feel equally strongly about those and are very, very hopeful we'll get the same result for those clients.
Absolutely, and congratulations, Jen, to you and your team. I have seen the work that you guys are putting into these motions, and they are so detailed. I mean, the law piece of it is, I mean, just so smart, so compelling. Of course, being able to craft that narrative of, why someone really deserves release, that's huge. And you guys have done an amazing job of working with families, getting those letters of support, getting the release plan set up, which I have seen a lot of compassionate release motions. And oftentimes, attorneys, they have a lot going on. Like Jen said, there's such a need for these motions right now. So oftentimes that piece slips. And lawyers just don't have the time to really put together a release plan. So Goodwin has been doing an amazing job with that. And then finally, as you mentioned, what I have found just incredible about the work that you guys are doing with these motions is not only are they leading to the release of these incredibly deserving clients, obviously that's huge, that's number one, but you're able to weave in these, policy positions as it relates to the changes in law. And that precedent that you are putting into these motions is beneficial, not just for your clients, but really for any cannabis offender, for any nonviolent drug offender incarcerated in the US right now, to be able to show, the progress this country has made in terms of criminal justice reform, drug policy, but of course, particularly the legalization of marijuana across the country. That is so impactful for other attorneys, for other pro se litigants who are seeking compassionate release or even release through the clemency process. So amazing job. We are so excited to be working with Goodwin and be creating that precedent and getting folks out. So again, congrats. And on that note of creating really impactful precedent, Fatima, I want to turn to you. You are working on you recently filed a petition for certiorari. I don't know if I'm pronounced as an attorney for how many years, but not a litigator, probably not hitting that, but a petition for the Supreme Court to actually take up the case. The case is Washington v. Barr. I would love for you to just kind of start with, you gave kind of a very brief overview of what is at the core of this case, but an overview of the case and the case history and kind of where we're at now.
Sure. So we brought this lawsuit on a pro bono basis back in 2017. It's a lawsuit that we filed against the DOJ and the DEA on behalf of 5 different plaintiffs. And essentially at the core of what we've been arguing before the federal court is that our plaintiffs' constitutional rights have been violated in a whole host of different ways because of the legal uncertainty that's been created by virtue of ongoing federal prohibition, despite the fact that we now have 38 states and territories that have legalized cannabis in one form or another. So effectively what's happened is you have millions of Americans, the majority of Americans, who have access to legal cannabis in their states, but who are still living under the auspices of federal prohibition. And so they are effectively, in many ways, prisoners of their own states. It's really hard for a lot of medical patients in particular who really don't have a choice but to carry medical cannabis on their person. It's really hard for them to travel from one state to another, especially on federally regulated modes of transportation, like the airlines. Like a lot of people don't even realize Amtrak is federally regulated and funded. There's so many different ways in which you will be put in a situation where you might have to interact with law enforcement as a result of carrying a substance that's still illegal under federal law, yet you're in complete compliance with state law. And so our firm really prides itself in being involved in impact litigation in all different aspects of our practice areas. Impact litigation is not new to us at all. Even before 2017, a lot of our practice had been land use and zoning. And in New York, there's a substantial landmarks law that is put in place to protect landmark properties, historic districts all throughout the state. And as you can imagine, there's so much architecture and culture and history to protect in the state of New York. And so our work, before our cannabis practice really launched, was heavily focused on this landmark work, which we would always represent activists, environmentalists, preservationist groups going up against city and state agencies in order to protect all these different properties. And so a lot of the work we did prior to getting involved in cannabis litigation was impact litigation. And so this was really a natural fit for us. We were approached by a number of different attorneys and activists in the space in 2016 to 2017 about figuring out a way to challenge some of the state health department regulations on medical cannabis in New York. A lot of the medical program at the time had been really in its infancy. I mean, in some ways it still is. The qualifying conditions that someone could access medical cannabis with were really limited and restricted. And so a lot of activists and attorneys really wanted to challenge those regulations. And so they were all sort of, meeting with each other, trying to come up and brainstorm ideas of being able to challenge these unfair laws. And every, discussion that Michael Hiller from our firm would have with these attorneys would always come back to the fact that despite any, injustice or irrationality in the state law that we're focusing on, it really all comes back to the fact that there is still overarching, it's always the shadow over everyone's head is federal prohibition. And so that's really the root cause of many of the problems that we're seeing in states, even where cannabis has already been legalized, either medicinally or for adult use. And so he came up with the idea that we should really go after the Controlled Substances Act and the irrational classification of cannabis with heroin as a Schedule I drug. It really all comes back to that. And so we were introduced to a number of different groups and individuals who we thought, had real stakes in the matter that would make really compelling plaintiffs in the case. And so one of the first plaintiffs that we were introduced to is Alexis Bortel, who is a 14-year-old child. She is now a cannabis advocate. She is a co-author of a book. She owns her own soap business. She's really an impressive kid, but at the age of 7, she had developed intractable epilepsy, and she had tried every FDA-approved drug that you could imagine. Her parents took her to multiple doctors where she lived in the state of Texas at the time, and she was actually told that after all of the FDA-approved drugs that they had tried failed, she was told that basically her last resort would be a lobotomy. So her parents were obviously not going to even entertain that idea, and they ended up moving to the state of Colorado, where medical cannabis had already been legalized. And there she was able to start taking cannabis oil. And she has now been seizure free. This is a child that went from having multiple seizures a day, sometimes multiple seizures a week, missing weeks and months at a time of school, almost, completely, non-functional for days and weeks out of a month, to now being this really impressive child, because she has been seizure free for almost 5 years as a result of taking medical cannabis. So it has quite literally saved her life. And as I was mentioning before about how so many Americans are prisoners of their own state because they are medical patients who are in violation of federal law, Alexis Bortel is probably one of the most powerful stories that we can share about what that is like, because not only does she literally rely on her cannabis as almost an EpiPen, where she needs to have it on her person at all times, but she's also, because of her passion and her advocacy and her ability to have her own book and her own company at such a young age, she has so many opportunities to travel and speak with leaders in Washington, D.C. and in all sorts of different places. But because of the fact that she can't carry her medical cannabis, she's really been deprived of a number of opportunities. And she actually was explicitly asked, I believe it was in 2018, while our lawsuit was pending, she was asked to meet with several members of Congress during, the National Lobby Day for cannabis. And she was asked to go and share her story, and she couldn't. We actually asked the court, for a temporary restraining order in order to give her just temporary access to travel and not have to live in fear of prosecution. And it unfortunately was denied. But so that's just an example of the many ways in which federal prohibition has really been destroying lives all across America. Our other plaintiff is also a child, Jagger Cott. He is someone who is diagnosed with Lay's disease, which is a really rare condition that kills most children by the age of 3. Jagger Cott's been taking medical cannabis for years now, and he's, I believe, 8 or 9 years old. Way longer than anyone was expecting his life expectancy due to this unfortunate disease because of medical cannabis. And once again, having difficulty traveling, accessing all different sorts of benefits as a result of federal prohibition. His parents are in constant fear every time they need to travel in order to get him his medical cannabis. And then we also have Jose Bellin, who is a combat war veteran. He suffers from PTSD as a result of serving in Iraq. And because of the fact that he needs medical cannabis to treat his PTSD, he has been deprived of a number of different veterans benefits that would typically be available to him. The VA has refused to administer medical cannabis to him, as it does to all veterans who ask to be treated with medical cannabis. And as many of you probably know, veterans suffer from severe PTSD, which often leads to suicide. There's some really horrifying statistics about how often veterans commit suicide. And medical cannabis has been shown in multiple studies to be a really effective treatment for PTSD in particular. And unfortunately, so many veterans are being, mistreated, completely untreated, oftentimes deprived of so many benefits and rights that they should be entitled to because they choose to treat with this substance. So he is our third plaintiff. And then we also have brought this lawsuit on behalf of the Cannabis Cultural Association, which is a nonprofit 501c3 organization that is dedicated to helping communities of color who've been disproportionately impacted by the war on drugs. They particularly focus on educating and providing support and resources to persons of color who want to enter the legal cannabis industry. And a number of their members are individuals who have been formally incarcerated and prosecuted and convicted of possession crimes, simple possession, and whose lives have been, extremely difficult as a result of having a record for simple possession. And so we've brought an equal protection claim on behalf of that organization. And then finally, we have Marvin Washington, who is a Super Bowl champion, former NFL player, and also an advocate and entrepreneur in the cannabis space. He has, interest in cannabis not only as a former athlete, considering the fact that cannabis has also been effective at treating certain brain injuries, including CTE, which football players in particular are, predominantly impacted by. But he also, as an African-American man, also understands the impact of the war on drugs. And as a result of federal prohibition, there are also a number of federal benefits and federally funded programs for minority-owned businesses that are inaccessible to any minority-owned business that wants to get involved in the cannabis space. So those are our plaintiffs. Each one of them has such an incredibly powerful and compelling story, different in many ways, but also all so similar in the sense that these are just people trying to live their lives who are in full compliance with their state's laws. They are not people that have records of constantly breaking the law or harming other individuals. Most of them are trying to save their own lives. And, because of federal prohibition, they really have had their lives completely turned upside down. So we brought the lawsuit in 2017. We brought a number of claims, as I mentioned, an equal protection claim because of the racially motivated basis for placing cannabis under Schedule 1. It's not a secret. The Nixon administration had made it pretty clear that they were specifically targeting Vietnam War protesters and African Americans by placing cannabis under that schedule, despite the fact that Nixon's own commission that he put together came out with a very lengthy report called the Schaefer Commission, which actually recommended decriminalizing cannabis. And he went against his own commission that he established and decided to continue putting cannabis under this highly restrictive schedule, notwithstanding the science, notwithstanding his own commission's recommendations. And it was very clear from audio recordings that have since been released after he left office that he was targeting these particular groups who he believed were using cannabis, predominantly. So we do have equal protection claims on that basis, in addition to the obvious fact that the war on drugs continues to destroy communities of color all throughout this country. We're really seeing a lot of this unfold even in police brutality cases. Right now, we're in the middle of a civil rights movement like we haven't seen in modern America. And, many people don't realize the impact that cannabis prohibition has really had on, law enforcement interaction with citizens. The war on drugs, which started and which was propelled in so many ways by cannabis prohibition particularly, that war on drugs really caused the militarization of our police force as we now know it. And as a result of the militarization of the police force, you now then have a very aggressive, hostile police force rather than a police force that's working with the community. And so it really does create a number of situations every time police are interacting with communities of color. It really creates a much more hostile and aggressive interaction than it otherwise would. And so, we feel really strongly about equal protection claims. We've also got claims as under the Fifth Amendment. There's the obvious fact that the prohibition of cannabis, in light of the fact that the federal government has acknowledged the medical efficacy and safety of cannabis in the patents that it owns, it is really irrational, so irrational that it is actually unconstitutional for them to continue placing cannabis as a Schedule 1 drug, despite the government's own acknowledgement. The fact that the government has in so many ways went out of its way to protect state legal programs, yet at the same time continue to criminalize it on a national level. So we have a Fifth Amendment claim as the fact that it is irrational. But we also have a fundamental right to travel, fundamental right to health, to preserve your health and your life. As I noted before about, individuals being prisoners of their own state, they really are often put in situations where they have to make a Hobson's choice between various fundamental rights, whether it's your fundamental right to health and your fundamental right to treat your health and preserve your life. And the U.S. Supreme Court and a number of other federal cases have made it clear that when you are making individuals choose between constitutional rights, you are effectively depriving them of constitutional rights. So we have brought claims on behalf of especially our medical cannabis patient plaintiffs, fundamental right to health claims, as well as a fundamental right to preserve your health and your life and travel. So we brought this lawsuit in 2017, bringing all these claims on behalf of our 5 plaintiffs. And interestingly, when we were before the lower court during an oral hearing, an oral argument, the judge actually admitted on the record that we had demonstrated that there really is medical efficacy to cannabis. There really hasn't been any official judicial finding before on the record in a case like this, where a judge has actually admitted and acknowledged that you can't deny the fact that there is medical efficacy to cannabis and that it has saved our plaintiffs' lives, is actually what he said. And so that really gave us hope. That really was something that we were hoping would have led to a more favorable result. Unfortunately, because you have to exhaust your administrative remedies in a lawsuit before any court, there is such a thing as exhausting your administrative remedies, which basically means that if there is an administrative agency that has been given power and authority to decide the issues that you're raising in a lawsuit, and they have the knowledge and the experience to do so, that you should really go through the procedures of bringing your grievances to that agency before going to a court. And so the lower court dismissed our lawsuit on the basis that we hadn't petitioned the DEA to reschedule or deschedule cannabis. However, we had actually compiled a lengthy chart showing that the DEA petitioning process is entirely delayed, unduly delayed, because if you look at every petition that's ever been filed with the DEA, on average, the DEA has taken about 9 years to decide a petition. And we are representing medically fragile patients. From our perspective, we didn't have the time to potentially wait 9 years just to get a result that we know almost certainly would have been disfavorable to our clients, because in addition to being unduly delayed, the petitioning process is also, entirely biased. There is institutional bias against cannabis in the DEA. It's not a secret. Every single cannabis petition that's ever been filed has been summarily denied, oftentimes on the exact same basis that were, claimed in a prior denial, even without looking at any of the actual medical evidence that's out there. So we, made our pitch to the court. They rejected it. They dismissed the case anyway. So we filed our appeal in 2018 with the Second Circuit Court of Appeals. We demonstrated, the undue delay once again before the Second Circuit. And interestingly, the Second Circuit, instead of dismissing our case, it actually retained jurisdiction, meaning it held authority over our lawsuit without throwing it out. And it did agree that we were supposed to go through the DEA petitioning process first, but it also acknowledged that we had really demonstrated that there really is almost no process. There's no administrative procedure if it's so delayed that you have to wait an average of 9 years. And so the court actually agreed with us, and it held what's called jurisdiction over the lawsuit for the purpose of giving us 6 months to file a petition with the DEA, and then instructing the government that it had to act with deliberate speed once our petition had been filed. And it held jurisdiction over the lawsuit so that if the government failed to act reasonably quickly, it could intervene. And that's something that we have never seen the Second Circuit do in a cannabis lawsuit before. So it was pretty historic from our perspective to see the court at least willing to challenge the government on the process in which it has considered petitions before it in the past. Unfortunately, we started to review all of the DEA petitions that had been filed regarding cannabis since cannabis had been scheduled. And we realized that the DEA has repeatedly taken the position that it actually lacks the authority to reschedule cannabis to anything above a Schedule II, because the United States is a party to a number of international treaties, including the Single Convention on Narcotics. And so the DEA relied on a DC Circuit case for its position. It's repeatedly stated it in a number of different denials of cannabis rescheduling petitions. And from our perspective, we didn't want to take the chance of filing a petition with an agency that claims to lack the power to give us the relief that we're seeking, because we weren't looking to reschedule cannabis to a different schedule. We were looking for a constitutional declaration that Schedule I is unconstitutional as it applies to cannabis, and the effect of that would be removing cannabis entirely from the Controlled Substances Act. So because we think a Schedule II classification would in some ways be almost worse than what we have now, Schedule II classification invokes a number of FDA regulations that would have to be complied with. Pretty much every state legal program in the country right now would be dismantled as soon as it is rescheduled to Schedule II. So we did not want to take that chance. And we decided that we were not going to go forward and file the petition with the DEA. We informed the Second Circuit of our decision and the explanation as to why. They decided to nonetheless dismiss our lawsuit. And so we have now filed an appeal with the US Supreme Court. We actually filed our petition on July 2nd. The case was formally docketed on the court's calendar a couple of weeks ago. And that actually brings us to how we ended up involved with the Last Prisoner Project, because as we were putting together our petition, asking the US Supreme Court just to hear our case. And so earlier, Sarah mentioned a term that most lawyers don't really use on a regular basis. A writ of certiorari basically means, and you said it correctly, is basically a petition asking the US Supreme Court for permission for them to even hear your case, because you don't have an automatic right to appeal to the US Supreme Court. As you might or might not know, the US Supreme Court takes only a very small fraction of the cases that are filed before it. They don't have the time or the bandwidth to take every single case that's filed before it. So they take a very small handful of cases. And they really make that determination based on a couple of things, one of which is whether or not the issues that are being raised in the lawsuit have national impact. Is this something that's really just affecting the parties to the lawsuit and not really having any expanded impact outside of that? Or are millions of Americans sort of in a very weird legal limbo that only the US Supreme Court can resolve? And then the other issue that they consider, which is related to the national impact issue, is whether or not there is some kind of conflict in the law that can only be resolved or addressed by the US Supreme Court. And so in our petition, we have demonstrated that both factors are at play here. There are circuit splits, as we call them, which are basically conflicts between the federal appeals courts in the United States. So with respect to whether you have a fundamental right to preserve your health and protect your life using medically safe and reasonably effective medical treatments, the Fifth Circuit has said that you do have such a right. It was actually in a case involving a state ban on chiropractic services. The court came out and said that because you have this fundamental right to preserve your health using, medically safe, reasonably effective treatments, that the state could not ban those services. And so at the same time, the lower court in our case actually said that you don't have any such fundamental right. And that was one of the bases on which it dismissed our lawsuit. And the Second Circuit affirmed that decision, which basically creates now a conflict between the Second Circuit in our case and the Fifth Circuit in that case as to whether or not you have such a fundamental right to preserve your health and your life. The other circuit split is whether or not the DEA does in fact have the power to deschedule cannabis because of the United States obligations under international treaties. So the DC Circuit has come down with a decision in the 1976, I believe, saying in not so many words that the DEA lacks that authority. The DEA has, interpreted that lawsuit to that case to at least say as much. But the Second Circuit in our case explicitly sent us back to the DEA to file a petition because they actually found that the DEA does have the power to deschedule cannabis. And so that creates another conflict in the law as to whether or not the DEA does have this power. So we highlighted those two circuit splits in our petition. We also highlighted all of the legal uncertainties that have been created as a result of federal prohibition, notwithstanding the fact that 38 states and territories have legalized cannabis. So, right now we're in the middle of a pandemic where cannabis companies have been deemed essential businesses. And yet, despite being given this, title, this sort of benefit, quote unquote, at the same time, when the stimulus package was issued, providing SBA loans to companies, small businesses operating within the pandemic or not able to operate because of the pandemic, cannabis companies and many other companies who don't even work directly with the plant, but that support cannabis companies, were all told that they do not qualify for these loans because cannabis is illegal under federal law. So, that's just one example of the many inconsistencies in the laws that have created so many burdens and obstacles for anyone in the space, whether we're talking about medical patients, whether we're talking about dispensaries, whether we're talking about, entrepreneurs, investors, adult users, everyone who's involved in the space, attorneys, accountants who are providing services to these companies. Nobody really is entirely clear as to what the rules are because there are so many different conflicts, both between state and federal law, as well as between federal law itself. Because as I mentioned before, the federal government is criminalizing cannabis on the one hand, but it owns patents on cannabinoids. On the other hand, it's passed congressional funding riders to protect state legal programs when it comes to medical cannabis. Yet the Cole Memorandum, which was meant to also protect state programs, was rescinded by AG, former AG, actually not too long after our lawsuit was filed. And so there's a ton of mixed signals coming out of the federal government, and it really creates a whole host of issues for anyone who's involved in this space. So we highlighted all of these issues in our petition, and in addition to doing that part of the work, it's also really important to drive home the fact that this does have national impact. And so in order to do that, a lot of litigants will get with what are called amicus groups to submit a brief to the U.S. Supreme Court asking them or supporting the position of a particular party to the lawsuit, either asking them to agree with the merits of the party's argument or asking them to take the case, agree just to hear the case. And so because we're at what I said before, the cert stage, where we're just asking for permission for the case to be heard, we are looking for amicus groups, which are friends of the court. We're asking outside organizations, outside individuals who are not parties to the lawsuit to support our lawsuit by filing a brief with the U.S. Supreme Court, telling them why their individual members, their constituents, why they are also impacted by the issues that are being raised in our lawsuit. And trying to really drive home the point that this does not just impact the 5 plaintiffs in our lawsuit. It really impacts millions of people, all different sectors of the economy, all different organizations, individuals from all walks of life. We have Americans for Safe Access submitting a brief. They represent, millions of medical patients across the country. And then we, of course, asked the Last Prisoner Project as a pretty unique organization in the sense that you guys represent specifically, you really are focused on individuals who are currently incarcerated, which is not something that a lot of organizations do. There's a lot of talk about social justice, social equity in the space, but most of it is really focusing on people who have previously been incarcerated and who have records. But what do we do about individuals who are currently sitting in prison for oftentimes simple possession while you have $1 billion industry, evolving every single day, and not one of the people who's involved in that space has to really worry about the sorts of things that someone who's sitting in prison has to worry about. So we reached out to Sarah because David Feldman of our firm had already been involved in a number of pro bono, engagements with the Last Prisoner Project. So we reached out to Sarah. We asked her, given, the Last Prisoner Project's incredible work, whether their organization would be interested in submitting an amicus brief. They're putting one together now, and we're so incredibly grateful to have their support. And so right now we're in the process of just getting as many amicus briefs from as many interested individuals and organizations who want to support this lawsuit, who want to have the U.S. Supreme Court at least agree to hear our case. So that's my spiel. Thank you again to the Last Prisoner Project. You guys have been incredible, and we're so really grateful for your work and your support on this.
Well, thank you so much, Fatima, and to the entire team at Hiller for taking this case on, really on behalf of the cannabis community, medical patients, of course, our constituents who are currently incarcerated or still feeling the ramifications of prohibition. And I know I've spoken with so many other advocacy organizations. You have done a really incredible job amassing a really diverse team of amici who are going to submit in this case. And as you mentioned, our amicus brief will really, if anyone was listening to last month's webinar on our policy work, our upcoming policy paper, it will be really reflective of that work, as you touched on and as you touched on a bit, and we will go much deeper into in your original filing. There is so much racial animus, clear racial animus behind these laws from the beginning, and that has continued to today through the war on drugs. And it's, touches every piece of the carceral state, from policing, that first interaction with police, all the way through sentencing, and these really lengthy sentences we're seeing for nonviolent cannabis offenders still today, like Kiara and Jen touched on with their clients. So we are very excited to be filing that. I think we have time for just a couple questions. Thank you all for describing the work that you're doing. I wish we had an hour for each of you to go more in depth, but I'm gonna get to a couple questions. And I know I see a lot of questions about, getting involved with LPP, or if you're someone that needs help, might need to take advantage of some of these legal services, please go to our website. That's lastprisonerproject.org. There you will find a little bar that says, do you need help? You can fill out a form, an intake form. If you want to contact us, there's a page to get involved, to volunteer. You can reach us at info@lastprisonerproject.org. And a couple questions. Fatima, I'm going to turn right back to you. You kind of touched on what the criteria SCOTUS is looking for when they decide whether or not to hear a case. But we have a question. What are the chances, or I guess what are the odds that this case will be heard? I guess, how many cases get put up for cert, and when is that decision going to be made?
So those are all really good questions. It's really hard to say how many cases they take, but the short answer is that the more momentum there is behind supporting a lawsuit, the more that there is pressure to really resolve an issue that is sort of bursting at the seams, the more likely it is that the court will take it. And, we're really confident that we now have 8 confirmed amicus briefs that are going to be filed on behalf of more than a dozen organizations and individuals who are supporting this lawsuit. And we think that's going to play an incredibly powerful role in getting us cert. Because the U.S. Supreme Court, as I mentioned before, is very hesitant about taking a case. But when they see that there are so many different people and so many different industries impacted by the issues that are being raised, they do feel more compelled to take on a case. And so what we're seeing now is there are 7 ballot initiatives coming up this election on cannabis. So we've already got 38 states and territories that have legalized cannabis. We add another 7 states to that. You're talking about almost the entire country on a state level having legalized a substance that continues to be completely outlawed on the federal level. And yet Congress has had decades to fix this problem. They've had decades. And instead of fixing it, they have placed a Band-Aid on a gaping wound. And so we think we really have driven home that point in our papers, and we think with the addition of all these incredible amicus briefs, we are feeling very confident that they will agree to take this case. Now, as to when that decision will be made, It really does depend on the briefing of our papers, because the government now has to respond to our papers, but they do have the opportunity to ask for an extension of time. As of now, the government's papers would be due on September 14th. And then that would give us, I believe, an additional at least 30 days to then submit a response to them. And then it's up to the court to sort of decide when it makes a decision, if there's going to be an oral argument. So it's potentially going to be decided by the end of the year. It could also go into early next year.
Well, thank you for that. I know there's tricky questions to answer. One more question on this. How can individuals, A, follow the progress of the case, and B, if someone is interested in submitting an amicus brief, how can they reach out to you or the Hiller firm?
Also excellent questions. I'm so happy to hear people interested. So you can follow the progression of the case on our website, hillerpc.com, or you can follow the Hiller PC handle. It's just Hiller, PC on Instagram, on LinkedIn, and on Facebook. Our social media handles are probably a little bit more up to date than our website, as we're constantly posting things, keeping people apprised. We actually just issued a press release last week about the docketing of our case. So the press release itself will give people a pretty current update as to what's going on. And you can also get a link to a copy of the petition that we filed with the U.S. Supreme Court. If anybody wants an individual copy directly from me, I'm happy to provide it. You can email me at fafia@hillerpc.com. You can also contact me at that email address if you're interested in submitting an amicus brief, or if you know someone who's interested in submitting one. Amicus briefs are due September 14th, so we are running a little tight on time. The good news, though, is that amicus briefs don't have to be long. They could be anywhere from 5 to 10 pages. So for an attorney, most attorneys are used to pulling out briefs within a week's time. So depending on who's able to write the brief for you, it might be doable.
I would say definitely for the Last Prisoner Project team, the tough part has been staying within the word limit. So probably for any attorney, definitely would not be hard on this case to put something in by that deadline, because there's so much to touch on. So thank you again so much, Fatima. I have one question that might also be, I think could go on for a while, but I'm hoping Kiara and Jen can speak to maybe just a couple of these things. We have a question asking, what are some of the issues you're facing connecting with and just having a client who is currently incarcerated?
Well, I think that given COVID, it's different than it was. We can't have face-to-face meetings with our client. We don't even have video calls with our client in Florida. And in fact, last week when I tried to have a legal call that was set up, I was informed that the phone system was going to be down for 5 days. And that is really troubling. But we've been able to connect emotionally with Richard, and his hopes are higher than ever. Hope really is the language of his soul. And that brings me to a recent quote, something recently that Florida Department of Corrections Secretary Mark Inch said back in March. He said that hope means we focus on what we can do instead of what could have been. Hope means we choose to have a positive attitude and act, even when everything inside of us wants to give up. Hope accepts that our past actions have consequences, but that we have set a path to personal change, redemption, and a successful future. If anybody embodies that, it is Richard DeLisi, and we have hope that he is granted clemency and a commutation of sentence so that he can be with his grandchildren in his remaining days. Jen?
Our experience has been kind of all over the map. We've been able to have very regular close contact with many of our clients, either through the prison email system or through established legal calls. When that hasn't been possible, and it kind of depends on the federal facility, and a lot, as Kiara mentioned, a lot of that their access to both email and phones depends on the severity of the COVID outbreak in the facility. Some of the prisons have gone through periods where they've been on total lockdown because of the spread. So in those circumstances, when we haven't had the opportunity to interact directly with our clients because of restrictions put on them by the prisons, we've been really working closely with their family members and advocates to gather the information we need, to get more background on their case or their individual story. And so we really have used a combined approach of working directly with our clients, but also with their family and advocates when we haven't been able to get into contact with them.
And I have one more question before I let you guys jump. Jen, this one's for you. I know it might not be super easy to answer, but I'd love to get your thoughts on. We have seen since COVID, I think now the BOP has the lowest rate of people incarcerated federally in the country right now. So they are obviously putting effort into decarcerating amidst COVID. BOP has obviously put out a lot of guidance on how to do this. Part of this is the compassionate release process. Yet you brought up the fact that across the board, AUSAs are taking the position that they're going to basically always oppose these motions. Someone is asking basically, why are they doing that?
It's a great question. So there's actually two things going on. There are efforts within BOP to grant release. Oftentimes that's to home confinement or to residential facilities, neither of which are as ideal as getting full release. And so in our circumstances, even where the prison has indicated that our clients may qualify for home confinement, we are still seeking relief in the courts to get an order of straight release home to their families. A lot of them have sentences that incorporated supervised released terms, and those are generally being held intact by the judges. So there are efforts being made within the prisons. They're just, because of the bureaucracy, even in our case, the judge found that due to the BOP's own lack of resources and manpower, our client, even though he was qualified, may just be sitting there. And so that's why we're taking the tack of just going as quickly as we can and filing relief in the courts. When we do that, though, the government, as in Fatima's case, has the opportunity to respond. And so our strategy has been to really advocate with the individual prosecutor that's been assigned to respond to our case and really tell the story, convey all of the arguments that we think are most persuasive, and to see if there's any way that those prosecutors, and some of them where in our case it turned out to be true, do become advocates, and they go up through the ranks in their own office to try and challenge some of these policies in individual circumstances where they think it's warranted and the prisoner is deserving of release. But oftentimes, I think the government lawyers are also very overwhelmed by the number of petitions being filed, that they had to create some sort of priority system. And that has led to them looking at the inmates with the most serious medical conditions and who are at the highest risk of COVID, and sort of creating hierarchies based in large part on the CDC guidelines. And so it's an uphill battle, but I still think that there's a lot of opportunities for advocates and lawyers to work directly with the government and U.S. attorneys' offices all over the country to really see if there's a way to become a voice and separate your client out from the statistics and like the number of petitions just sitting on their desk and get them to really pay attention to the individual story. That's what we did in our case, and I thought it was really effective. And so that's one way to kind of change the course.
Well, I think that is all the time we have for today. Thank you all so much for coming on to kind of explain the work that you've been doing with Last Prisoner Project. But most importantly, thank you all for the work that you are doing. It is so incredibly important right now. As you each touched on, we are in a moment of real change in this country, and you are each a huge part of that through the different pieces of this pro bono work that you are doing. And we as an organization, and of course our constituents, are incredibly grateful. I know we will be keeping up to date on all of these aspects on our website. I think the panelists have put out their contact, their websites. I know everyone is anxious to follow along. So thank you all so much. Thank you to everyone for joining today, and we will see you next month.
Thanks, Sarah.
Thank you.
Thank you, everybody.